Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Greg, my man. It's always nice. Hello, Greg. It is always nice to get to do a podcast with my brother from another mother, similar last named friend and trial partner, Greg Unatin. Thanks for being with me always and today.
Well, thank you, man. That's special, and very happy to be here.
Yeah, and we're here to talk about a nice verdict that we were able to obtain about, I don't know, month or so ago now in Erie County. And, I was thinking before we get into it that, you and I have been trying cases together for 12 years now.
Wow.
Go back to 2013 was the first case we ever tried together.
The Brand case. Yeah. How could we ever forget that one?
Brand v. Intertech. And it's been all, what is that? Uphill, downhill since, whatever the good one is.
I know. I get that confused.
But no, it's always a lot of fun to try cases with you just because we have such a backstory and experience together. And, I can, just trust you entirely to, we just kind of have that working flow. And it just makes life so much easier and trial so much more enjoyable. So just want you to know that I appreciate you a lot. And, you're always having been alongside with me on these cases means a ton. So anyway, enough with the gushy stuff. We'll
hey, man, you're the yin to my yang. Come on. Really means so much to me a lot.
So this case, the nutshell summary of it seems like a relatively straightforward case. It's a doctor is in Erie County is exiting a surgery center that he was performing procedures at to walk back across the street to a hospital to perform another procedure. And when he exits the door to go outside, unbeknownst to him, there's snow and ice on the landing. He steps down, he slips, he falls. He injures his back and he injures his shoulder and has to have surgeries. And, according to us, it essentially costs him a really promising career. Did I get that about right?
Yeah. Mm-hmm.
So, but it wasn't that straightforward. And, like any case, there was a lot of hurdles. This one seemed to have particularly large number of hurdles, starting with what I always thought, I guess I was somewhat worried initially, so we got brought into this case way late on in the game. So we tried this case in September of 25, but the fall in question happened, when was it, Greg? 2013 or 14?
I think it was 13.
Yeah. So it happened 11, 12 years before the trial. And, the reasons for why it took so long to get to a trial are manifold and, probably, kind of boring and irrelevant to get into. But the fact of the matter is, we're here trying a case from, that occurred and the events happened over a decade earlier. And I remember running this case by my wife, Lacey, and she just hated that fact. Like, what? Like, how can there be a, but I'll tell you that through focus groups, but also just that, you have to kind of understand, like, whenever somebody has a negative reaction about something, you've got to kind of explore, like, why did they have that reaction? What was going on in their mind? And, some of the focus group people brought it up. They didn't have as visceral reaction as Lacey did, but they, people were questioning in focus groups, like, why is this case so old? why, and what happened was there was a misunderstanding in a lot of people's minds of why did he wait so long to file suit? And so people were sort of thinking in their heads that, he didn't file a timely suit and he waited until many years later to finally sue. And that kind of created a lot of suspicion. But when, it was explained, well, no, he filed within 2 years. And in fact, the reason that the timing of it was because he had no other options given, what happened between him and his employer, UPMC, providing that context totally changed and not only neutralized, but I think, maybe somewhat, this bit dramatic, but like weaponized that aspect of it. So, before we go on to like some of the hurdles, I kind of got brought into the case first. And, as you know, because I just get obsessed with cases sometimes, I was spending an inordinate amount of time on this case, while you're crushing through everything else in the firm and just, crushing cases all about, and then I'm like, Greg, now we're literally going to trial. This case is not settling. When you first started looking at this case, what struck you about it, good and bad?
Well, I was sort of enticed about it. Because I saw how much time you were putting into the case and effort. And I know you would not put that much time and effort into a case if you didn't think that it was worthwhile. And I had heard you passingly say that this was a great client, a serious injury. It could be a really big case. Initially, I had a very favorable view of it. And I think as you got deeper into it, you started to identify some of the weaknesses, and that's tended to sway my mind a little bit as well. And I think one of the major weaknesses was just the fact that this case had been going on for so long, and the plaintiff, our client, really had not been doing anything in terms of a career or a job. And the suggestion was really that, well, despite the injuries that he suffered, which in this case were a lumbar spinal herniation and also a rotator cuff tear, the insinuation was that he could get over those injuries, or he had gotten over those injuries, and he could go back to work. So that was the major weakness. And I guess, the strengths still remain that this seems like a really good client who had a great job, huge earnings loss on paper, right? To the extent anything is still on paper, but there's a huge earnings loss on the board that we could put up there. But when you put it in context of what has this guy been doing and why isn't he trying to go back to work, to do something with his life, the case sort of hung in the balance. Is it a strong case? Is it a weak case? I don't know.
Yeah. And I think, we've got to add a little bit more to the timeline. So, listeners kind of understand, so they can kind of put what happened in context. So, Dave falls in March of 2013, and it's an unwitnessed fall. He, at least there's no record of him telling anybody about it immediately. There's no photographs, there's no video. According to Dave, he's sort of stunned, does not realize he's really injured. He gets right up, he walks over, he performs his last procedure and sees at least one patient that evening. Again, this is more from the suspicious vantage point of UPMC. And by the way, the case was David Irwin, Dio, and Monica Irwin, his wife. They're both doctors versus UPMC Hamot and UPMC Hamot Surgery Center. And one thing before I continue on with the timeline that some people might be scratching their head about, which was unusual, and there was a lot of really good lawyering by Tibor Salamosi, who had been the lawyer on the case from the beginning, who then brought us in to try the case. And what he figured out was that he could get around the comp immunity, workers' compensation, because Dave, our client, was actually employed by a separate UPMC entity called Regional Health Services, RHS, which is sort of their employment arm. And that allowed him to be able to sue different UPMC entities, the surgery center and Hamot, for his fall. So that's how we were able to proceed on a civil claim, despite there being, an obvious work comp component to this. So Dave does not get any medical care the night of the fall. And in fact, he doesn't get any medical care for these injuries for, I think, at least 3 weeks. And he actually wasn't even planning to get any medical care at that point. But, as he described it, kind of his back and his shoulder kept kind of getting worse day by day. He went right back to work. He was basically, working a full schedule after this fall. But according to him, every day it was kind of getting worse. And it culminated with a coworker just randomly kind of like, slapping his shoulder, kind of jokingly, like, oh, stop about whatever that was. And he yelps in pain. And again, according to him, his coworkers are like, Dave, this is enough. You've got to go get checked out. You're clearly hurt. He goes to the medical services at UPMC and they send him for imaging. And then that's when, his lumbar spine instability. And mind you, he had very significant low back medical history prior to the fall. But then his shoulder, it was discovered, was very badly injured. His left rotator cuff and labrum were very badly torn. So, then, other aspects of it. And when you go into trial, sometimes you can't help but be worried about, well, how's this going to come off? How's that going to come off? And, there was a debate about when he actually even submitted the incident report about the fall. There was an incident report, and he said he filled it out, because I believe this happened on a Wednesday night, and he said he filled it out on Friday, which was the next time he was back at the surgery center, because his main home base was at Hamot, which is the main hospital. And then periodically, depending on his schedule, he would go across the street and do procedures at the surgery center. And so he said the next time that he was back at the surgery center, that's when he filled it out. However, representatives of UPMC, said, oh no, he didn't fill this incident report out until like 3 weeks later. And, that turned out not to be really much of an issue whatsoever. But going into trial, I was worried about that because, just from the credibility factor. And I guess, that raises sort of a positive of something that we had going for us was a really good client. And when I say a really good client, this is the second time that I've gone to verdict and gotten a good verdict where my client was a doctor. And there's clearly, if you can get a doctor as your plaintiff client, you're in a good position. I think because people generally, they like doctors. They generally trust doctors. They may not trust the medical system so much, but generally they trust doctors. They like doctors. They respect doctors for how hard, they've worked and the training they've undergone, and they're smart people, obviously. They're intelligent people. And they, not always, but usually have, some degree of bedside manner. They know how to, work with people. And so, Dave himself, as I was saying to you yesterday, Greg, I think he was a very formidable plaintiff to the other side. Do you agree with that?
Mm-hmm. Yeah. I mean, I think there were a couple things that we worried about going into trial, like the incident report not really being, the incident itself not being reported until 3 weeks later. I know I worried a lot about claiming damages for the back surgery because he did have a significant prior back injury about 4 years before this incident in question. And he really didn't have any residual throughout these 10 years since the injury. After his lumbar fusion, it was a successful surgery. So, I had some qualms about bringing those in there, those injuries and the worries about the incident report as it might affect his credibility. But I think, as you just insinuated, if you have a great client who just comes off very credible, and it doesn't hurt to be a doctor, but certainly doctors are not the only people who could seem very credible. Those concerns about bringing in maybe borderline injuries, or maybe something about a delay in reporting an incident, they sort of just dissipate, right? They're not as, to me. I mean, it's like it was a complete afterthought now. Like, both of those issues were non-issues.
Yeah, which, I think in most premises cases, that's, they're always such a, I mean, every trial is a huge credibility issue. But certainly, an unwitnessed fall, where you're claiming money, that is, in most instances, you're very, very worried that a jury is just not even going to believe this person. They're going to suspect, some percentage of people out there are going to suspect that this person is making this up, or looking to, game the system for money. But I think when your client's a doctor, that really, alleviates that concern. At least now I can see it in hindsight, because people just, they, a doctor, this guy's not lying. Like, this happened. It was, even from focus groups, it became very much like people just were like, well, no, I have no question this happened, but I want to know more about, how this injury impacted him. And and then it really became, like you said, establishing, and how do we go about establishing this claim for his lost income? And we're going to get into that in a moment, because that presented us, I think, with a lot of, very unique issues that I've never had to address, and, tough decisions that you have to kind of just hope you're making the best decision for trial. But I can remember you and I going back and forth about, do we drop the back? Do we not? Do we bring it in? And you understandably were like, I think we should just outright drop it, because they've got us on that. They've got him with lots of bad prior, and there was some really bad stuff in his priors, like he was being recommended surgery. He had, horrible stenosis of the lumbar spine, to the point that it was documented he had foot drop at times. It was so bad. And so that was an issue. And, I ultimately felt that by dropping it, though, it created a lot of problems, because if you dropped it, then they could point to that still and say it wasn't just his shoulder, it's also his back. And they're saying that's not even related. And, so I ultimately convinced you that, we should say the back is related, but point out very blatantly to them that he had a good recovery from the back. His spine surgery went just great. And if it was just his back, we wouldn't be here. He would have been right back to work. And I think that ultimately played just fine. And we really made it. It was all about the shoulder. The shoulder was the problem, but the back was related. It just, he had a great recovery from that.
And it's worth noting as well that, you were just very concise in your presentation of the evidence on the back. With his treating surgeon, your deposition for use of trial was maybe 35 minutes tops. And you were able to get in a little bit of testimony from that surgeon about his work with David, because they worked together in Erie as well. He wasn't just a treating surgeon, he was a colleague. So that's a credit to you in how you were able to identify an issue that, wasn't the biggest part of the case, sneak it into the case in a concise way that kept it relevant, but didn't bore the jury and didn't, make them resent you for presenting evidence about something that really isn't a permanent problem for David.
Yeah, and I forgot about that was another sort of factor in my mind for keeping that testimony in, because, again, you look at the unique context of this case, and I think it's worth kind of pausing and talking about Dave's backstory, because, not only was he, he was very sort of like understated in his testimony. He was almost stoic, but I mean, he emoted enough during his testimony, but his story was a really good one, which was essentially that he grew up on a farm in Evans City. And mind you, I mean, I can't even remember because he lives in North Carolina now. I can't even remember the number of Zoom, you know, conversations that I had with him trying to learn about his background and understand, like, how do we put this story together so that it's most compelling? And I think he really just had a compelling story. So he grows up on a farm, and I think his dad was a teacher, but they really were a very little means. And Dave basically was he was born, he had dyslexia. It was discovered at a pretty young age. He had real troubles in school. But despite that, and despite sort of that, off the bat, sort of, genetic obstacle that he was given, it talked about that he was very inspired as a kid that, their quote next door neighbor, who he said was basically like, 4 or 5 miles away because they lived on a farm, but that this gentleman down the road was both a farmer and the town doctor. And that just really connected with Dave as a kid. Like, it just blew his mind that you could be both. You could be, this kind of, grassroots, dirt under the fingernails farmer, and also the person that takes care of people's health in the community and that people look to when they have health concerns. And that became his sort of singular focus, was to become a doctor. And, he helped pay his way through college on a football scholarship, and worked his butt off in spite of his dyslexia. He would get accommodations as necessary for testing and so forth. And, obviously, putting the dyslexia aside, a very, very bright guy, and also very hardworking and driven. And, he gets into, I think he was actually in a different, maybe he started at LECOM, then he goes to a different medical school to finish up. And he does like a series of residencies and fellowships to become this very, very specialized interventional pain medicine doctor. So he was both an anesthesiologist, and he would do these interventional procedures, for example, like a kyphoplasty, which is, they inject essentially like bone cement into collapsed vertebral bodies. And, there's not a lot of doctors in the country that really had his skill set, was kind of my takeaway.
Right, right.
And, then he moves back to, he meets his wife. They move back to Erie so that she can go to medical school and pursue her own medical dreams at LECOM. And he starts doing anesthesia, and then, again, working with them, I'm like, did you get any awards? Like, oh yeah, we didn't tell you about that. And, so he was working for a private practice group called Napa. And he really just becomes this like superstar within UPMC Hamot's medical system, because they have him working at Hamot doing both the interventional procedures and anesthesia. And he's getting these, what was the things called? What were the award? The Guardian Angel Awards, where basically like patients were so pleased with his care and the outcomes that he got, they would literally make donations to the hospital. And I'm, I went down this path because it circles back to Ray Sekula, his spine surgeon, and his testimony, and how we were kind of weighing whether to bring them back in. So UPMC then hires him away from his private practice group, and they say, we want you to come and work with us, because of, they saw what this guy was providing them. He was going to create this whole pain program, which was going to be a huge profit center for UPMC Hamot. They made him the chief of pain medicine at Hamot. They were featuring Dave in these advertisements where he's, looking great, white coated with all the other neurosurgeons and high level doctors. And which brings me back to, in that ad, for example, and by the way, this is just, all of this stuff is just killer material to you're not creating the impression, it's the truth, but creating that impression to the jury of like, this is a very worthy person. That they're going to be okay finding in this person's favor if you have the liability facts to back it up, because he just was an impressive guy, and he was somebody, who really had been providing a lot of value and benefit to the Erie community. And then, you go full circle, he's in this great ad, and who's one of his partners is Ray Sekula, and Ray Sekula winds up being the surgeon that does his spine surgery. And then in his deposition for use at trial, he just sort of on his own started talking about, separate and apart from my care and treatment of Dave, he was an amazing doctor, and he was basically like the go-to guy. He was the only guy I would send my patients to. He worked like a demon, which was a huge part of the case, was showing that this guy was not a lazy, individual that was looking for an easy way out.
Mm-hmm.
So, how did you feel from your perspective that Dave's testimony? I think, I don't know, we're probably jaded, but what did you think worked, and what did you have questions about with Dave's testimony at trial?
Yeah, well, in hindsight, everything worked based on the result, right? When it was going on, I almost felt like, I don't know, maybe David was a little bit too confident, or maybe seemed a little conceited at times, or just, couldn't stop talking about himself and how great he was. But really, that was probably just my cup is usually half empty, pessimistic perspective about most things, and concern that the jury wouldn't like him. But in reality, they loved him. And looking back, it really was great testimony. He held his own in so many ways. And I don't know if it was on cross or on direct. He had this one statement, a piece of his testimony that I always remember. He said, "People told me, Dave, you'll never go to college and graduate college. I proved them wrong. People told me you'll never get through medical school. I proved them wrong. People told me you'll never actually become a doctor. I proved them all wrong." In the timing of that, in the grand scheme of his entire testimony, was so perfect. So you could tell that he put a ton of thought into it. And I just thought it was great. That was my impression. One thing I will note too about his testimony that I think is, again, worth noting, is that it was like all day long. He was on that witness stand, including cross-examination, but even just his direct, to get this whole story out about his origin story, which you just mentioned, and the next part that you haven't mentioned of what will be more relevant to the case. It took a long, long time, and it sort of violated that rule that, I don't know where it came from, of don't keep your client on the stand too long. Get them up and off, on the stand and off the stand. You don't want them to look like they're whining or sound like they're whining or say something that could hurt their case. But he was the case. And given all the hurdles we needed to get past, some of which we've talked about, not working for such a long time, long-term disability, which we'll talk about in a little bit, there was just so much we had to bring out. You had to bring out, right? Good and bad, to tell the story that you wanted to tell. And I'll go back just to mention, in terms of our prep, what I've noticed is that, you need to find a story that you like to tell. And I think that's good advice for anybody, but you especially, when you get that story that you believe in, that you just become so laser focused. And it's not the story you want to tell. It's the story that needs to be told. Okay. The fact that you want to tell it just proves that it's the one that needs to be told. So I think in order to get that whole story out, he had to be up there a long time and do what he did on the witness stand. And your direct was really masterful, I thought.
Well, thanks. It did go way longer, because I think you and I, pride ourselves on trying to be as concise and to the point for a variety of reasons as we can. But as you mentioned, he was the case. He was the case so much that we were strongly considering at one point calling him as our first witness. ultimately we decided not to do that for some other strategic reasons. But I mean, it was kind of like they're going to get up, and they did, and say, basically, this guy's full of it. He's not really hurt, and he's just milking the system. And he's looking for, he's been waiting around for his jackpot justice from all of you. And they said that pretty much in no uncertain terms, in opening. And so we were literally like, maybe we should just call him first and look, the jury's either going to like him or they're not. But I want to talk about something that you and I were sort of texting last night, and I thought this was a really interesting insight, and it's making me think a lot, which was, you talked about how another doctor had represented John Alonge and Dave Irwin. You said they demonstrate how the inability to follow a career pursuit, which takes years of effort in making, speaks louder than the injuries themselves. And then you went on, we always tend to think about the severity of injury first when evaluating cases, when, the aftermath is just as important as the severity of the injury, if not more important. And I think that's so spot on. And I think sometimes it's hard when you're first looking at a case to think of the impact that whatever the injury is, no matter how severe it was, turned their life into a direction that it was not otherwise headed. And it kind of makes me think, I don't know if you've ever seen, like, Mark Lanier has this thing in closing he'll do where he'll put up this hand, this drawing, and it's basically like the path of life of a person, and it's heading a certain direction. And then they're detoured into this like cesspool by the defendant's, actions or inactions, rather than allowing to proceed on the natural, path of where they were supposed to be headed, which then, ties into, Mitnick's, unnaturally thrust into their life type thing. But I think that point that you made, and we've seen it in so many cases, and sometimes you're like, where did this verdict come from? And I think it has to do with more than just the injury itself. It's the interference with their life, and certainly with doctors, if it impacted what their entire life's passion was and their identity and all that kind of stuff. That really clearly resonates with people, that this is a very, very real injury that's worth a lot of money, if you have to make up for it.
Yeah, and I guess, really relates back to case selection, and how many times do we just focus on the severity and the permanence of the injury at issue before we decide whether to take on a case, when we should really be starting not just with the severity of injury. Of course, it's always important, but what are the person's major hobbies? Like, what is their passion in life? For some, it is their career, doctors, maybe lawyers, other professionals, perhaps, those types of avocations, which require years and years of training and education, tend to take over your passion in life, I suppose. But it doesn't have to just be about work. It could be about playing pool or hunting, or surfing, whatever the hobby or sport, recreation might be, that is essentially robbed from the person due to their injuries.
Yeah. So I think, a takeaway for people listening out there is to, as part of that damages component, and it can honestly, I think, almost make your damages testimony easier to conduct, because it really then just goes back to storytelling and the history of the person, and and you find out those things. Obviously, with doctors or hyper specialized professionals, in a sense, it's easier because it's so obvious, like, what the thing is that was everything to them and then was impacted. But I think with anybody, focusing and working hard to find, like, what was that thing to them that was like their main focus of life, that was, whether it's their identity or the thing that they had invested the most time or effort or got the most joy or satisfaction from, and how has their injury, whatever it is, impacted that, and just showing that contrast between what it was and what it should have been versus, what happened as a result of the defendant's inactions. Now, I want to talk about the moral story battle in the case, and I also want to talk about, how we addressed the economic loss claim and a decision about collateral source issues. But, first I want to talk further about, me in particular. I get sort of like obsessed with different things that just like resonate with me. Obviously, one of them is what you had mentioned to me last night. But I'm currently obsessed with this Joe Freed presentation and really trying to hone your case down to the light switch issue. And there can be a few light switches, I think, on sort of different levels, but really like pairing out and cutting any arguments or liability claims that just, they aren't it, so to speak. And I think also as a trial attorney, wrestling with the fear of doing that. And so the concrete point in this case was that, again, Tibor, the lawyer that had worked the case up, he had, smartly pled two theories in the complaint of liability. One was that they didn't maintain the snow and the ice outside this door, and they were at fault for that. And, whether that's the snowplow people weren't doing their job or policies and procedures or whatever. Okay. So there shouldn't have been snow and ice where he stepped and fell. And then secondarily, Tibor has a construction and building contracting background, and he knew that this door in question was almost certainly not code compliant. And that turned out to be true. We consulted with an architect, Bob Stevens, who's great, wrote a terrific report and, explained exactly why, this step, because there was a step down out of this door. It's kind of a weird, wonky door. It swings out. There's an abrupt step. And in fact, a funny little side story, I doubt she'll ever listen to this. And our, both the opposing attorneys were very good, Lisa Preston and Jamie Schumacher. And Jamie had tried other cases before, and, she beat me on a case like a year and a half ago. Very good trial attorney. But she, on the site inspection, when she was opening the door for us to inspect it, she literally fell out of it. And she fell down right in front of our experts. And immediately was like, sort of half joking, half like shocked, like, you did not see that just happen. And, of course, people are thinking, oh, we've got to find a way to work that in, that even the lawyer, on a sunny day, she fell out of it. But we started to dig into it. And there was even other really good kind of juicy stuff with this door. The building plans back in the day called for the door to be flush without a step. And, we in one sense, we kind of had them dead on the door, but then we found other stuff that they'd been approved by the county and the city as the building was permissible and code compliant, And, I can remember you coming into the office into my office when you first started looking at the case, and you're like, I don't see the step argument. It doesn't connect because he didn't fall, he slipped on ice. So, I'm going to take seriously how it first strikes you. We did a predict study on this case, which I would need, I think, a whole other podcast to kind of unpackage that. I think the fact pattern was highly imperfect that we submitted to that. We kind of threw the whole kitchen sink in, and it was not nuanced at all. And it helped us figure the nuance out of the case. But again, in the predict study, people, some people were kind of like, yeah, like I can see that step. That's kind of messed up if that was a code violation, but it wasn't like driving the case, because at the end of the day, what caused the fall was a slip on ice, basically. And then that was, And notwithstanding that, I still was like, no, but that code violation, like we've got them dead on that. We can do it. And there was a moment where I was thinking of going entirely on the code violation, dropping basically the ICE component of it. But then I did another focus group, and it just kind of, people were like, why are you talking all about this step and these codes and these blueprints and stuff when the guy slipped on ice? And that kind of finally convinced me. And I'll talk about like what our ultimate theory was. But I can remember, and this is just, again, part of, I think, one of the many stress factors of being a trial lawyer is that you have to make decisions and you don't know if they're right or not. You're doing what you think is the best under the circumstances. But the quote safe thing, where nobody could have faulted me or us, would be bring them both in. Make the stare claim and do the ice. But go ahead.
Well, there's a word that gets tossed around in our office that's sort of like a dirty word. You started using it first, I think. It's sponsorship. You know what I mean? Whenever I want to be vindictive to you, because you say that word when we're working up a case, and I'm like, oh man, how could I be so stupid to want to bring in that evidence? Like, what's the purpose of sponsoring evidence unless it's critical to your case, right? The jury's going to think, oh, that must be really important for them to say it. But in my mind, the juror, I don't think it's that important. So you don't want to sponsor something that you don't need to win the case. Do you know what I mean?
Well, right.
So I think that's kind of like what it came down to in part. And then there was also the fact, that we talked about last night, that they told David to go through this door, right? And I guess this kind of relates a little bit more to the storm. Maybe I'm kind of getting ahead of myself, but I mean, do you want to talk a little bit about that concern?
Well, yeah. And I mean, just, real quick, for any listeners not familiar with this concept of sponsorship, I can't adequately summarize it, but the book on this issue is called Winning Jury Trials, Trial Tactics and Sponsorship Strategies by Klonoff and Colby. And I was turned on to that book because Rick Friedman, in a footnote in Becoming a Trial Lawyer, said that was a very important book to read. And it is. And I would highly recommend people read it. It has some, I think, thoughts and advice in it that I don't agree with, but I think the sponsorship idea, to the extent that it comes up so often in our office, and it is a bit of a dirty word sometimes, because if it comes up, they're basically like, why are you sponsoring that? And I think in a sense, you can boil that down to, why do you want to bring something other than your best evidence into the case? And because when you do that, inevitably you're almost bringing something else extra that you have to prove, which is not what you want to do. And so if we bring both the step and the ICE issue in, now it's almost, you want to think in your mind that jury will say, oh, it's either or, but they're more likely to think that we've got to prove both of those, or else why are we bringing them up?
Yeah, you kind of have to think, what's the bare minimum that we need to prove to win the case on a particular issue?
And that, that for every plaintiff lawyer, and I have to constantly remind myself of that, what is the simplest, easiest, and least, full of obstacles path to winning on your given points, on the liability, on causation, on damages, and always coming back and thinking through that. And do we need this? And do we need this? And so ultimately, despite the fact that we had, this supposed code violation and our architect was all jazzed up to talk about it, we dropped it entirely and did not even make it part of the case. And instead, over time, from us just talking and thinking, which again is always just a very important part of trial. It's just thinking, thinking through things, talking things out loud, running it by ChatGPT as your thought partner, us riffing, doing focus groups. We eventually came to this realization about what happened. And so the policy at the time was that 5 p.m., the surgery center would lock its main doors, okay? Because, David testified that he comes over at noon that day to do his procedures at the surgery center, and he remembers like the sidewalk and the entrance in the main area was like pristinely maintained by the snow plow guys, like to the point that he was annoyed how much de-icer was getting into his boots. So hyper safe, hyper taken care of, and he goes in those main entrances. But then they had a policy that around 5 p.m. they would lock those main entrances. And the reasons for that were not entirely clear. It was like maybe they didn't want random people coming in after hours or just whatever it was. They locked those doors. And then there was limited entrances for people to exit. And for a doctor to exit and go back across to the hospital, as any doctor would need to do, there was only one door, which was this rear exit door that Dave ultimately exited and slipped and fell at. And what we did was we just assumed, and this was another always hard part, it's just like you had to believe Dave that there was snow and ice there. And if there was snow and ice there, there shouldn't have been snow and ice there, okay? I mean, aside from the fact there was an active snowstorm going on, but that's another issue. And so what we ultimately said is, look, we are not saying that UPMC and its grounds crew needed to take care of every square millimeter of this entire campus free of, flakes of snow, snowflakes and ice. All we're saying is that if you direct, your staff and doctors to exit a particular door, you have to make sure that that door is safely taken care of and safe to exit. That's all we're saying. And, juxtapose that with, look how well they took care of the main entrances. They just didn't do this back door. And then you get into like, well, why? And really the thought process of focus groupers at the end of the day was basically like, they just kind of overlooked it. It wasn't like a primary door. It wasn't something that, they're busy taking care of all these other areas. They just missed it. And there was snow and ice there and there shouldn't have been. And it really came down to be that simple. But it was that control aspect that UPMC directed them out there. And if you're going to do that, then you got to make sure that door is safe.
Right.
But I will say that, we believe that's the best theory. And it ultimately turned out it was the best theory. That was a winning trial theory. And we trusted ourselves and went forward with it. I will say, very fond of our client, Dave, and we support him 100%, but he was not happy with my opening statement when he realized that we were not proceeding with the defective step because he thought that was the best argument, and I had to sit there and tell him, like, look, I've done this before. We've done focus groups. We've tested all this different stuff. We're going with the theory that tested best. But that did not give me a warm and fuzzy feeling as the rest of the trial's going on that my client is quite displeased with our theory right off the bat and just kind of added to that pressure. But that's just part of the process.
Yeah. Well, everybody needs to stay in their own lanes when it comes to these trials, right?
Yeah. And he made up for it by giving great testimony.
Sure.
So do you want to talk a little bit about, sort of how the moral, this kind of moral battleground unfolded? Again, not particularly apparent going into this, when you first hear about this case.
Yeah, sure. I mean, and you have the details down a lot better than I do. But I mean, I think what we were most concerned, or at least one of the things I was most concerned about going into the case was, again, the fact that Dr. Irwin had not worked in over 10 years since this fall and his injuries. When in reality, his back was no longer an issue. His shoulder had healed to a certain extent, although I think we sort of underestimated how messed up it still was. It was constantly dislocating. And I think we sort of underestimated how important that would be pre-trial. But it was a big part of our permanent damages evidence, the fact that he would go to just to be evaluated for functional capacity evaluations, and his shoulder would dislocate as soon as he tried to lift more than like 30 pounds above his waist. And he wanted to continue with the FCE because he wanted to work, but the examiner, a therapist, shut it down, popped his shoulder right back in. Obviously, you can't tell somebody to continue to do that type of an evaluation when their shoulder just popped out. So, but getting back to our initial concern, like despite the fact that he still had a really bad shoulder, this guy had a significant amount of experience and training in the medical profession. And I think our concern was that, there has to be some job out there in the medical profession, consulting, expert work, more low key, low physical impact medical doctoring that he could have been doing over the last 10 years. And I think that was troubling because it didn't fit into that mold of the hero story, right? The persevering plaintiff who, despite their injuries, finds a way to make it work, deals with their limitations, and continues to be a meaningful member of society. So, fortunately, you figured out that there was a way around this concern, and it came in the form of a trail of emails between David and management, the RHS, his practice group, in the period of time pretty much right after his initial surgeries, not only for his back, but for his shoulder, where David was really interested in getting back to work. And he wanted to find a way to make it work, despite the pain that he was certainly still experiencing at that time, despite the limitations. And as these emails unfolded, as you showed the chronology, we saw essentially a distancing between the management of his practice group and David. That was all brought about by the decision on the management group that he was no longer of use to their practice and to the patients of Erie who needed pain management services. Then you could probably describe some of those emails a little bit better than I can, but they really resonated, and it became a huge part of the story in this case. So we didn't focus so much on the fact that he had no options about going back to work because his shoulder was so bad, it kept popping out. We just told the story of his desire to go back to work in the months after his injury and how he was shut down by UPMC. And then, and essentially that was all we needed to show. It took care of 10 years of concern.
It did because, I thought the emails when we, and I will give myself a pat on the back for this because, Tibor had essentially requested, or I may have while Discovery's open, but, I wanted access to, because I would ask Dave, do you have any emails supporting that? He would tell me about some of these interactions. Well, I think there was an email. Do you have it? No, they shut my account down. And so I insisted on getting, all of his work emails from, and somehow UPMC was able to dig them up as part of that discovery response. And they turned over, I don't know, there was like 10,000 emails, 99% of which are just, BS garbage that's irrelevant. But what was in there was a very telling story where, UPMC administration, before he's getting these awards, you mean so much to us, thank you for everything you do, Dr. Irwin. Here's another satisfied patient, president of Hamot emails the president of RHS, you mean so much to us, Dave. They're bending over backwards to contract with him, to bring him on, get him under contract. And there was another, whole aspect of this we didn't even talk about that was a very hot button topic was, as part of his contract, as part of the bylaws of UPMC Hamot, Dave had to become board certified of some sort, anesthesia, pain medicine, whatever. And before this fall, he had taken the board exams on 3 separate occasions and failed every time. And so they were saying he was not going to pass his board exams, and thus his time at UPMC was going to end. by contract, by the bylaws of the hospital. He was literally not going to be permitted to work here. And that was a huge argument. And there was something like, at the time of his fall, he had maybe a year to a year and a half left within which to take and pass the board exams. And, we countered that by, talking about his dyslexia, but also really showing these emails that they knew when they contracted with him, when they brought him on and they're paying him all this money with this huge upside bonus structure and they're naming him chief and they're putting him in their advertisements, they knew that he had failed his boards 3 times. They actually added additional time into his contract within which to take and pass the board exams, and so we argued that, look, this guy was so valuable to them. He was making them so much money. They were going to do whatever it took to keep him on board. They were not going to just oust this guy. And, there was such a stark contrast between, Dave, you're amazing. Dave, you're the best. We love you, Dave, when he's making all this money for them and he's their golden boy. And then he gets hurt. And then I think I said in closing, it was like, when he's writing back to them, it was like, Dave, who? Yeah. And there was these just brutal emails where it's like Dave writing to the head of RHS, like, hey, I called you. And this woman, she's emailing him all the time. You're the best. You're awesome. Thanks for being here. You mean so much to us. And then after his injuries, he's emailing her and he's like, hey, I called you 3 times and left voicemails. Oh my gosh, I'm so sorry. That must have slipped my mind. I must have forgotten. They were blowing him off and they put him out to pasture. They're like, take your work comp benefits, take your disability benefits and just buzz off. And it was just very, very obvious that is what happened because he wasn't valuable to UPMC anymore. And so, they cast him out and they said, you're getting disability benefits. That's good enough. Leave us be, which created a big problem for them later because a big part of their defense was twofold. One, Dave made no attempts to, what's the term, Greg, for offsetting your damages?
Mitigate.
Yeah, you didn't mitigate your damages. You didn't go out and get a job. You could have done all these jobs. And then we turned around and said, hey, look, who's the biggest employer? Who's the biggest private employer in the Commonwealth of Pennsylvania? Who was the largest employer of doctors in the Commonwealth of Pennsylvania? It's UPMC. And this dude went and asked, what can I do? What are my options? And did they make any accommodation that brought him any jobs whatsoever? No. But then in the 11th hour before trial, they hired Dave Zach, who's a good guy, a good vocational guy. We've used him before. And, Dave is basically given marching orders to come up with all these fake jobs that Dave supposedly could do. And it's like, well, where were these for the past 10 years, And he literally writes, well, I went and talked with a UPMC business recruiter and they said these jobs are there. And it's like, well, did anybody go and tell Dave about this? Well, I don't know if they have to, do that kind of stuff. And, and then we go down the list of the jobs that they supposedly come up with. And meanwhile, they come up with them like 3 months before trial, totally bogus. And we just go down. He can't do this one because of board certification. He can't do this one because of past qualification. He can't, everyone just crossing off. Again, a very long examination, but I think it was necessary to just, show the hypocrisy of all that stuff. And so this ties into another part of it, but I think that really then showed and I think sometimes you and I don't know, and sometimes it only kind of becomes apparent in trial, but that moral battleground, like who has the moral high ground of the case, the plaintiff or the defense, we, I think, really got it. Okay. We had them because ours was not only betrayal, as soon as you're not valuable to us, then, basically like buzz off, leave them out in the cold. Just an absolute overt betrayal of trust and love and caring for this guy. But then it also directly undermined their moral battleground, their moral argument, which was essentially laziness and greed. Mm-hmm. They're basically like, this guy's just been not working, holding out, waiting to get his big payday. And that our moral ground not only had the betrayal component, which is really powerful, but it really, really dented their argument that it was because of his laziness. Like we had them. He was trying to go back to work with you and you did nothing, but
Right.
now he's the one that's the problem.
Yeah. And in our damages model for the case, in terms of economic damages, we incorporated what he could have earned if he was able to find employment in some lesser paying job, right? Not a real full-time doctor, but maybe I think there was something along the lines of like
pharmaceutical
concierge
sales
doctor
or concierge doctor,
insurance reviewer, right?
Right.
Or a doctor who reviews claims and for insurance companies. And so our economics expert essentially offset his predictions of future economic losses, loss of earnings by like what, $250,000 roughly?
Yeah.
Which was essentially right, or the average or the midpoint of what David Zach was saying David could earn and could have been earning. So, we took that moral high ground in multiple ways, and that was just one more by assuming, all right, let's just take what the defendant's experts say and we'll assume that's correct, and we'll incorporate that in our loss of earnings predictions. Yeah. So it was great.
But within all of this, there's, another, kind of lurking boogeyman in the case, which was that Dave, for a decade, basically, had been receiving essentially $22,000 per month as part of his disability package. And our choice was going into this trial when we know the defense is basically like, what the hell has this guy been doing for the last 10 years? I mean, that was literally it. Like, what's he been doing? The big mystery, But we knew that was a problem. I did focus groups and I wouldn't tell them about the disability benefits. And people were like, well, what's he been doing? Like how is he even living? How are they subsisting? And then, well, maybe he's getting disability benefits. It's probably covering all of it, or maybe he's doing maybe he's working under the table. Like all this bad stuff was like coming up in that black box of not telling them about disability benefits. Cause obviously the default as plaintiff lawyers is, we keep collateral source out, because generally speaking, it's inadmissible at trial. And after a lot of wringing of hands and worry, we had to make another big decision. And a decision at times during the trial was like, oh, I think maybe we made the wrong decision here. of just bringing it all in. We brought in that he was on workers' comp. We brought in that he was on disability through UNAM. Again, weighing the pros and cons of these things. The obvious con was, they had that one really compelling slide with our economist showing how much money he'd already earned from his disability plus his big payout. And it was something like, I don't know what it was, like $5.5 million or something crazy, the amount of money that he got in disability benefits. And I'm thinking maybe this wasn't worth it. But on the flip side, it gave us a lot of very helpful stuff. It gave us that he was disabled. Unum, we were basically like, Unum's in the business of finding people not disabled. And they couldn't find a job for this guy. They tried to do back to work. And then, there was this great functional capacity exam where Dave goes back to, get graded for his level of disability to return to work through Unum. And his freaking shoulder dislocates, picking up like a 20-pound weight. And his, blood pressure spikes, his heart rate spikes, that the physical therapist has to manually relocate his shoulder back into the socket during the exam. And then Dave's like, I want to continue with the test in it, which is great. It shows this guy was really motivated to get back to work.
Right. Yeah. We were really concerned about that slide that the defense showed and just the whole introduction of long-term disability benefits. I mean, jurors could look at that number and be like, why are we here about a slip and fall where this guy ended up getting $5 million anyways, long-term disability benefits. But believe it or not, I think the jury just did what we always hope they will do, and we worry sometimes that they won't, but they followed the law. Jim Fallon, our economist, he mentioned in his direct testimony that he did not offset the earnings projections by long-term disability benefits because it's a collateral source, right? And he explained to the jury what a collateral source is and why it's not admissible. Although it was admitted, right? That was the irony of it. It was all admitted into the case, but honestly, it still wasn't something that the jury could consider when awarding damages, right? There was no jury instruction on that from the judge, but Jim Fallon, our economics guy, he kind of brought that jury instruction out, so to speak. So I mean, I thought that was interesting, and I hope that's the reason why the disability benefits didn't really play a part, because the jury was following the law per Mr. Fallon.
Yeah, and I mean, it's like history's written by the victors, and we can say, oh, what it seems so obvious and apparent, like what we did was the right decision, but it did not at all feel that way. It did not feel that way pre-trial. There was lots of times during the trial I was like, I don't feel like this trial is going very well, and I was regretting or questioning some of these big decisions that we had made. Maybe we should have done this, maybe we should have done that.
I always feel worse knowing that we're trying to put one past the jury, because I feel jurors are too smart, right? And they know that someone's getting disability payments and can't just not be working for 10 years and supporting a family, right? While their wife isn't really working either. The jurors know. And so putting it all out there and just being completely honest with the jury, brutally honest, I always think that is the best if you can do it. And
Yeah.
that's why I was so relieved when actually we were a little concerned, because the defense had a motion in limine to try to keep out all like disability and workers' comp, right?
Because
they
like
didn't.
Bizarro World, they didn't want the collateral source. That we did want it in.
And we wanted it, and then eventually they just conceded, and we're like, okay, great. So,
but no, I think your point is dead on. That it's like the truth has some way of always kind of seeping out. And there are certain motions in limine that you can make and that are legitimate, and it's just an issue that you can feel cleanly is not in the case and shouldn't be in the case. But a lot of times when there's those big issues in the case, and we tried another case a few years ago, and there was a big, and we won't go into it, but there was a big kind of moral issue in the case, and we eliminated out. But at the same time, it just like you couldn't, it just was like, it was there. It was just kind of like lurking around. And I think in this one, 100%, I was like, right or wrong, it's going to feel better and cleaner to just say what it is. Like this is reality. And it was kind of like once you brought it out on the table, people were like, oh, okay, that makes sense. Now I can understand how they've been living so far. And it just kind of took out a lot of the power of that, that defense and the concern of like, well, what's this guy been doing all this time? Because I was what's he been doing? What's he been doing? But, a few other, again, I think as trial lawyers, you always have to be, like you said yesterday, a little bit suspicious, looking out for things, where is maybe the defense playing a little fast and loose with things that, again, we can call to light. And, I think it was maybe just not, as in-depth preparation or what, but there was a cross-exam of Dr. Irwin by defense counsel, and they were using these supposed guidelines of when Dr. Irwin could take the board exam, because he had testified, look, I was, because I could no longer physically practice medicine. I was no longer in active practice. That was one of the requirements to be able to sit for the board exam again. That's why I never sat and took it again. And apparently years later that changed. And maybe, there was a later guideline. And without really disclosing to Dr. Irwin which guideline they were cross-examining him, well, they were showing, well, I'm going to read to you what it says. And it says that you don't have to be in active practice. And he's like, which one is that? That doesn't sound right. When I was, and he was really like incredulous on it, but it kind of made him look a little bit bad. Like he didn't go and take that test again. And, and it just kind of felt like, why weren't they showing that to him? And so that evening I emailed defense counsel and said, I want to see the guideline that you were cross-examining on. I'm entitled to know what that was. And it was like crickets. And the next day I was like, look, I'm not letting this go. I want to see which guideline. I want to know what guideline you used when you cross-examined him. And then lo and behold, I get an email back. Oh my gosh, I'm so sorry. Like one of our associates must have screwed up. And yeah, we thought it was the 2009 standard, but it turns out it was actually the 2022 standard. We have our one witness coming in about board credentialing at the hospital. We'll clarify this with him tomorrow. And I'm like, oh no, we're going to get an instruction from the judge to publicly declare what had happened, and so then now the judge has to make a special announcement, to the jury that defense counsel had used the wrong, exam. And then, I obviously went after their credentialing guy about that, pointing out, well, you weren't here yesterday, but let me tell you about what happened. And just, again, capitalize on, that misrepresentation and perpetual credibility battle that's always their trial. And, the takeaway again is, nothing earth-shattering, but you've got to be looking for the things that you can capitalize on, that are not necessarily, they're maybe a little bit outside of what the case is about, but that's also what the case is about. So
yeah, I think Dave was right, our client, to doubt the veracity of that handbook that they were using. Not that it wasn't an accurate handbook, it was just the wrong year. It didn't apply to the time period when he could have been taking his boards, or couldn't be taking his boards. So, but trust nobody, I guess, is what I want to say. When the defense, inadvertently or not, may represent things a certain way, when in reality, it's much different.
Well, and the converse is true. You have to be, I think Mark Lanier says, like assiduously accurate with the truth of the case. And, if you don't prepare enough, or you're sloppy in whatever guidelines or research that you do, or the wording you use, and I've fallen, victim to this before, and you say something that, or you take a point or take a stance that's not accurate, or is not quite the truth, a good opposing lawyer is going to bring that, to the jury's attention. They're going to rub your nose in it, and it's going to impact your credibility. And so, on the flip side, you've got to be really careful about, whether taking a chance with this, or, I think this is it, and they probably won't put it together, or whatever. Like, don't do that, because it's very, very likely to backfire. And even if it doesn't, it's probably morally, ethically not the right thing to do. So just a couple kind of like wrap up points. I don't know if there's anything, else that you really want to kind of talk about in this case, but, I thought one thing I really enjoyed doing was that, UPMC at the last minute, proffers this report from this orthopedic surgeon in Chicago, Stephen Chudik. And he had never examined, never met. It was a records review only. And it was one of the most vicious reports that I've ever seen. I mean, just outright calling our client a malingerer, motivated by money, his injuries. None of the injuries are related. The surgeries performed by his surgeons were unrelated. And he even said the shoulder surgery was unnecessary. I mean, it was brutal. But it was just so off the reservation that, we've tested this before, but we tested with a focus group. Like, look, this guy got hired, to write this report. Oh, he got paid $21,000 just to write this report, by the way, without his testimony. the focus groupers are like, this guy's coming in, and it hurt UPMC. And, I made a point in opening, let me go with all the doctors, on our side, on their side. And oh, by the way, all of Dave's surgeons, they're all UPMC employees, by the way. And they're going to tell you that these injuries happen in this fall. There's this other orthopedic spine surgeon from the UPMC hired. He agrees Dave's shoulders from the fall. And I'm like, there's just one doctor who says otherwise. This guy, pull this slide up, and we just have Stephen Chudik's face up there with, the key information: never saw, never met her, when paid $20,000+, whatever. And then, to our surprise, when we get towards the end of the trial and you're about to stand up and fillet Dr. Chudik on cross, they stand up and they say their case is over. They're closing the case. We rest, and they're not even calling this guy, which I thought was kind of hilarious.
Well, believe me, I was looking in the back of the room, waiting for him to walk in so I could size him up, and then I started thinking, oh wait, I don't see anybody. I might get a break here.
Maybe the last second the door pops open, like smoke billows in, and there is Dr. Chudik. But no, never happened. I think because they knew that he was going to look really bad and he was not going to help them, which just gave us another fun nugget in closing. Go through I remember what I said in opening. Oh, I was actually wrong about this. Sorry, everybody. Dr. Chudik, mysteriously never made an appearance at the trial. I wonder why. And that closing was fun. And the closing was fun because we just had good stuff to talk about. We had, the morality play. I could really now in closing, highlight the betrayal and what they did to this guy, and that, they loved him. He was a commodity to them. He was an asset to them. But when he became, less valuable and he couldn't make them all that money, they kicked him to the curb. They ghosted him, basically. It was enjoyable to, sort of retell Irwin's, origin and hero story in closing, now in the new context of the jury understands what happened to him, what UPMC did with him, and then, rolled into a nice and comfortable, evil man argument, which I always love to give, which I just think works very well. And, I think that I'll just close by saying it was a relatively short deliberation. I think it was a couple hours. And I don't know about you, I still didn't feel very confident at all. I thought there was a very good chance we'd still lose that case at that point. And I thought the very interesting aspect of the case is that the jury was made up of probably 9 people, mostly men, probably 55 or older. And there was a younger guy, maybe 2 guys like under 40. And then there were 2 women that were fairly young, like probably late 20s. And I know the one woman was, I think she was 25, and she had said that she was I think like a bartender or something like that. And to my surprise, who does the 4-person turn out to be but the 25-year-old bartender, which I thought was really interesting. And I think, at least I heard, you never know. I mean, you and I don't really talk with jurors much anymore, but, Tibor did and Dave did. And they had been told that essentially the 2 younger women on the jury were the ones that advocated for more money on the lost economics, which I thought was really, really interesting. I don't know what can be necessarily drawn from that. Do we like younger people these days? Not sure. And then their liability, I guess there was a fair discussion on the liability, and what they ultimately agreed on was not so much that these 3 snow removal guys were negligent themselves, but that essentially UPMC was negligent for understaffing, because we had shown, this massive campus that, 3 men were responsible for covering, and pairing that with, the weather data for the day, was able to tell a compelling story that, if you only have 3 people doing this, you're going to have patches of snow and ice present.
Yeah, which is another example of something that came up through discussion, not only right on the eve of trial, but during trial. I remember when we were driving to the courthouse, and you said, you know what this case really comes down to? There's 3 guys trying to handle the snow removal on all the sidewalks and 2 helipads for this gigantic campus, right? Because we had concerns going in that a jury was not going to blame 3 guys who have been working for Hamot for probably much of their lives, one of which came in, had recently retired, worked for what, like 35, 40 years as a snow removal person, was the nicest guy you can imagine. And, he talked about his job and what he did. And, you did a great job with cross-examination of this gentleman because, you weren't evil with him. You weren't aggressive. You just brought out what you just said, that this was too much work for just 3 guys, 2 helipads, everything I mentioned. And there was a funny exchange about how this particular witness hated shoveling the helipads because it took so much time. They had to go out. They couldn't use their tractor. They had to go out and do it by hand with a shovel. Then there were 2 of them. So
yeah, no, and he had that line. I was like, and was that, it was like, are those helipads easy to take care of? He's like, oh no, and he's like, it seems like the more we shovel, the bigger it gets. And everybody laughed about that. And he was just like a super good guy, you know what I mean? And he was just, you could just tell this dude's like a great dude who loved his job. But I could also sense in his direct that, he was a straight shooter. He was just going to talk about the reality of what that job was like. And, he would talk about it was, way more cozy to stay in the plow than get out and hand shovel areas like where Dr. Irwin fell. And, that they were basically hauling ass to cover, that entire campus. And we showed him those photos of these street views we took of it was unbelievable the amount of area that these 3 guys are responsible for. And yeah, he was like, I love my job and I worked really hard at it. And it was a hard job, and I was like, you guys were working basically round the clock, 24/7, to try to take care of this place. But, by your own testimony, you could only do basically a full sweep, every like 3 hours or so, or 4 hours, yeah. It's the best you could do.
It'd be easy for the jurors to forgive these 3 individuals, great guys, hard workers. And you recognized that, and you got past that, and the ultimate blame was placed on their employer, the hospital, for putting those 3 guys in the position of trying to make this entire campus safe during an eerie weather event,
right?
When that's really just, it's not fair. So kudos to you again.
Kudos to us.
Getting to the corporate player.
Corporate malfeasance, pulling the mask back on the corporate beast. So I'll just finish because people, not to toot horns, but people were always like, well, what the hell was the actual verdict? So the total verdict was $7.25 million. And it broke down. Past economic loss was $1 million. Future economic loss was $4 million. Past non-economic loss was $1 million. Future non-economic loss was $500,000 for Dave. And then they awarded Monica, his wife, $750,000 for loss of consortium, which, again, great outcome. Wish I could say that, we absolutely knew that was going to happen. We did not, but, it was good and super, just verdict. But definitely righteous and appropriate. These 2 had been through a lot, and, this guy really, really was cost a lot. So, ultimately happy ending, tough slog of a trial. It was only a week long. It felt like 3 weeks. But at least I had you there to try it with, along with Diodigo, our go-to operator. So happy memories now.
Thank you for including me. It was exhilarating and fun, as always, to be with you and, just put our minds together and do good things.
Definitely. And for anybody that's gotten this far into the podcast, I love sharing stuff. So if you want, opening, closing, PowerPoint slides, anything else, have questions about the case, just shoot me an email or call me. And that's it. Well, Gregor, another one.
I'll see you on the other side.
Yes,
of
absolutely.
This door.
Yeah, absolutely. All right, buddy. Till next time.
Thanks, man.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.